SJC-10864, Commonwealth versus Binns.
Good morning, counsel.
Good morning. May it please the court. Jeffrey Baylor from Mr. Binns. In this case, we contend that Mr. Binns' statement to police should have been suppressed. Just by way of background, Mr. Binns spoke very little English. He was a native of Brazil and therefore spoke Brazilian Portuguese. Framingham Police Detective Calvao acted as an interpreter. Detective Calvao was a native of Portugal and therefore spoke continental Portuguese.
But he had extensive experience dealing with people who were speakers of the same kind of dialect that your client spoke.
It's true, but there's nothing to show, that he's a certified interpreter or anything like that. There's just
Didn't he testify before Judge Bornstein, and didn't Judge Bornstein make findings as to that? That he was able to communicate effectively in that regard?
Yes, but not that he was like certified or anything official.
That's not dispositive.
Right. But that's more of just background. I think it really comes down here to what the words actually used in the Miranda warnings were, whether or not they spoke a different form of Portuguese. That's just sort of maybe an explanation for the problems, but does not address what the actual problems were. There was an agreed translation that was used at the suppression hearing and at the trial that set out the Miranda warnings along with Mr. Binns' statement. First off, we contend that Mr. Binns was never properly told that if he could not afford counsel, counsel would be appointed for him free of charge before question.
May I interrupt? Just
Sure.
the big picture.
Yes.
He received the Miranda warning several times,
4
correct?
times, yes.
Your position is the Miranda warning he received was not properly translated to him.
Correct.
But you don't dispute that there were 4 different sets of Miranda warnings.
Right. There was
And so it's the language of the warnings that you want us to focus on.
exactly.
Can I ask you, too, on that? Didn't he have the ability to read them in Portuguese? There's no suggestion that he was illiterate.
Right. But there's
So at the same time that the officer was translating them, they were also pointing them out together and reading them.
well, I mean, there's nothing to say whether or not Mr. Binns actually read them. I think, well, there's 4 in the 4 separate sets of Miranda. The first one was done off a wall chart in the police station.
In Portuguese.
In Portuguese. And I think the exact language of Detective Calvao was, you can read along if you want. So we don't know if Mr. Binns read them, understood them, or anything. All we know is what words were told to him.
Is there a translation of what was on the, what, is there in the record what the Portuguese translation stated and what, if retranslated back to English, that translate?
Yes.
Was it a good translation?
Yes, and it's even in the footnote of the judge's decision that's in the brief. In that particular version, the language at issue was, if you don't have possibilities to pay a lawyer, one will be named to itself. So first, we say that was not adequate, and then the next 3 were similarly inadequate.
If I, for the moment, grant you that he wasn't told that an attorney would be provided, since he did ask the question, even after at least 2 Miranda warnings, said, gee, but I can't afford one, essentially. Clearly understood that he wasn't going to be able to get one. Granting all that, didn't he then invoke, and wasn't there then a complete cessation of communication between police and the defendant? So isn't the real focus here what happened in the interval that isn't on tape, and whether or not he then initiated completely on his own, unprovoked, further communication? Should we be looking there?
No, I think you should be looking at the language, because if he's not properly told,
Well,
he
but I'm
can't
saying
make a
that, yes, but then he says, you think that, you think it doesn't matter. You think that he,
No, I think it does not matter, because if he's
And if
not
he does
if
invoke.
he is not properly told, so he doesn't understand in the first place, then he can't make a proper decision whether to cut off questioning, whether to start again. So he's told that he's not properly told, and then his follow-up comments were, is there a way he asked, is there a way for me to have a lawyer? And police responded, it's up to you. And he said, but I don't have money to hire a lawyer. And this was there after the second iteration. And to me, that means like he still does not understand that if he wants a lawyer, that one will be provided for him. Similarly, in the fourth iteration of Miranda, he said, they asked him, do you want a lawyer? He said, I didn't think that would be possible. So even looking beyond the language, his responses made it clear that he was not understanding that a lawyer would be appointed for him. But I think the first thing the court has to determine was he ever properly instructed, and if he wasn't, then that's it. You shouldn't be going any further. I already set out the first one. In the second set of Miranda, well, let me just back up for a minute. The 4 sets of Miranda, 2 were shortly after his arrest. The first one was from the wall of the police station. Then he was brought into an interrogation room. He was given a second one. They asked him if he wanted to speak. He said, not today. And then they woke him up the next morning, or it's actually later in the morning, because this first part was was early in the morning. And they re-instructed him again. He said, I want a lawyer. And then as the police got up to leave, he said, no, I'll talk. And then they instructed him the 4th time. So in the second time, he was told, if you don't have possession of hiring an attorney, you be supplied or recognized. And then in the 3rd and 4th, he was told, if you cannot obtain a lawyer, the court will point one out to represent you. So even though
then it goes, and when you do go to court, if you have no assets, the court can point one out to represent.
right,
That, of course,
that's
suggests he has to
the
go to
second
court.
problem. I'm sorry, I didn't hear.
That would mean he'd have to go to court first.
Right, and so that's the second problem. He's being told not that he's going to be getting one just then and there during questioning. He's told that if he goes to court, he could get one. So even if he was properly told, then he's told when you can't have a lawyer until you go to court, which again is misstating his rights.
Well, isn't the whole point for the police to just stop questioning when someone invokes their right to counsel? And isn't there indication throughout that that's exactly what the police did here? They just stopped questioning. It isn't so much that an attorney will be appointed immediately and brought in to accompany the questioning. Mm-hmm. It's that the police stopped questioning. And that's what happened.
They did, and then he said he asked them if they were members of the Mormon Church, which he was concerned about, and they said no, and he said I'll talk. But
and then didn't the detective inform him that they couldn't speak with him without counsel present? And they took some time to make sure that he was actually willing to speak with him, and this was a waiver.
They did take some time, but the problem is that he was never properly told what his rights were, so that he's making a decision whether to talk or not without ever knowing or without ever being told properly what his rights were. I mean, regardless of what happens afterwards, if he's not told properly, this is what your rights are,
Are you claiming that the Miranda requires somebody to be told that they can have a lawyer brought to them for questioning?
No, I'm saying that not necessarily brought to them, but before questioning.
Right, and when the police stop questioning,
Yes.
which is what happened here, then that's before questioning.
Right. So I'm not following what you're saying.
You're suggesting that he was somehow misadvised because he wasn't told that they could, that he had a right to have a lawyer appointed for him at, not at his expense, so that he could have the lawyer with him during questioning.
So we're talking about beyond the first part, we're talking about the prior to questioning aspect. We're talking about, they said to him, when you get to court, you can have a lawyer appointed out for you. So that's a secondary problem beyond the misstatement of the rights. They also told him that he could not have a lawyer until he got to court. Now, this just adds to the problem. And there was various statements made by police. And sometimes they told him that he could have a lawyer at time of questioning, and then later on they told him, you can't have a lawyer until you go to court. So there was some proper, in that case, there was some proper statement of what should happen, but there was also these improper statements telling him that he couldn't have a lawyer until he went to court. So that's just in addition to not being properly told that a lawyer would be appointed for him. Now, pointed out does seem similar to appointing, but in language, but it's not. When you think about it, it's not telling him we're going to give you a lawyer free of charge. It's just saying, hey, when you get to court, we'll point someone out. It doesn't tell him that it's free. And that language is similar to the language in the Sang case cited in my brief, where police said, we'll find you a lawyer. So they're not saying that the lawyer is going to be without charge. They're just saying, we'll find you a lawyer. Furthermore, even if this was all proper, there was still no voluntary waiver of Miranda or voluntary statement. These problems added up to him not understanding what was occurring and not acting voluntarily. Even though he invoked his right to counsel and then said, I'll talk, he never was told what was his rights were properly, so he could not voluntarily waive them. Furthermore, when he invoked his right to counsel, questioning didn't cease. Police said to him, he said, do you want a lawyer? He said, yes. And then they said, in further explanation, do you want to explain your side of the story, or do you want an attorney present? Again, telling him that it was his choice to either speak now or wait until he got to court until a lawyer was present. So we contend that even if everything was right, he still was not acting voluntarily in making the statement. If there's nothing further on that issue, I'd like to reach the second issue in my brief, which is hearsay statements of the decedent, Carla, should have been excluded. Now, there is an exception to the hearsay rule for statements of a decedent to show a motive to kill. But that exception only applies where a defendant would have known about these statements and was likely to respond to them. For example, this court in Borodine found proper statements that a decedent said, I'm going to leave my husband, and then her husband killed her. But in Seabrooks, this court found that such statements are not admissible merely to show a hostile relationship between the parties. And that's what the statements here were used to show. There was three sort of sets of statements that were admitted. Mrs. Ferreira, who said about a year before this happened, the decedent told her that Mr. Binns was jealous and they argued about the church.
Well, I take it that's exactly what your client told the police, that he and his wife had been arguing about the church, right?
Right.
Is there anything here that the defendant didn't already tell the police, was in his mind, was part of the relationship, was part of his anger?
Well, I mean, it reinforced what in these particular words, it reinforced what he was saying. She also testified that the week before this incident, there was an argument about him wanting to return to Brazil and her wanting to stay in this country. In that Mr. Binns broke items in the house. There was also Ms. Dos Santos who testified that months before, she was told that there was an argument about financial problems in that I can't read my writing, so we'll say financial problems. So these statements should not have come in under the exception to the hearsay rule.
Well, assuming the confession comes in and the other evidence of this really horrific crime, how are these statements prejudicial?
Because they added, I mean, Mr. Binns made this statement just saying, you know, what was wrong, his point of view, and this added to the jury's determination of premeditation by saying, oh, the decedent is telling other people this must have been really bad. It added to this statements that were made in the confession and provided the jury with another reason to find premeditation. Just in this case, only premeditation was found as the theory for first-degree murder. Also, in the closing argument, the prosecutor used this evidence to show propensity, citing the testimony from these witnesses saying this was building up over a long period of time and this is what happened. Again, to reinforce that there was premeditation.
Now, I can't recall. I know the judge sort of set out in some detail the defendant's confession, but did the defendant also talk about these problems building up over a period of time and then sort of exploding?
Yeah, he said he snapped. Yes.
But that this was there were a series of tensions in their marriage around the religion and
right, but nothing to say that it was
coming to their home.
so bad that he was premeditating, that he was gonna act, and that's why I'm saying that these statements contributed to the determination of premeditation. In fact, the big argument from defense counsel was, this isn't first-degree murder. Mr. Binns just snapped. It was over whether or not there was premeditation in this case.
Okay.
Also, in the closing argument, we contend that the prosecutor misstated what's needed for deliberation. I mean, for premeditation. The prosecutor said deliberate premeditation isn't a matter of planning. Only a time to reflect is required. Now, premeditation is planning, and there must be reflection. It's not enough to just have a time to reflect. There has to be a reflection.
I take it the judge must have instructed the jury that the judge was the one who would tell them what the law was, not the lawyers.
That's true, but...
And then he properly instructed them on this issue?
That's true. But the jury listening to the prosecutor, and then, you know, the murder instructions clearly aren't the most easy thing to understand for a jury. And the prosecutor's putting it in the simple way. There was doesn't have to be planning, there just has to be time for reflection. So even though the judge did properly instruct, this was enough.
Well, there doesn't have to be planning, there just has to be a decision.
Right, I mean, maybe instantaneous planning, there has to be a reflection, not just time enough to reflect. And that's really the problem with the prosecutor's closing.
Counsel, your time is up. Thank you.
Thank you.
Good morning. May it please the court. Fawn Bolero Anderson, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And with me today is Lee Hettinger. He's an Assistant Attorney General now. When he moved over to the AG's office, he kept this case and was sworn as a Special Assistant District Attorney to remain the trial prosecutor. Turning to the first issue, which is Miranda, the police in this case fully conveyed that the defendant had the right to have counsel present prior to and during the police questioning, regardless of his inability to pay, and the record indicates that the defendant fully understood this right. The main concern raised in the defendant's brief is that the defendant understood that his right to counsel was linked to a future point in time. However, that argument overlooks the defendant's invocation itself. The third time the defendant was given his Miranda rights, he stated, "I would like a lawyer to come by my side before answering any questions." And this was following a discussion where he told the police that he didn't have the ability to pay for an attorney. So clearly he understood that he had this right, and he did in fact invoke it. The defendant's next concern is that the defendant was essentially left between a rock and a hard place because he was told he could either have an attorney present or he could tell his side of the story. Even though that may functionally be true, as the police departments are not required to have a station house lawyer come to the station, all that matters is that there was a valid waiver in this case. That was done here. After the police made that statement to the police, the defendant still invokes and says, "Yes, I want an attorney." The question becomes, did that clarifying question taint the defendant's thought process as far as waiving that particular right to counsel? And I think the exchange that happens later, the fourth and final time Miranda is given, the exchange between the defendant and the police shows that he understood that he did have the right to have counsel present there during the questioning based on the conversation between them. The police officer says, "Okay, and after finishing reading the rights, you said you wanted to have a lawyer to be present to answer the questions, correct? Do you want a lawyer?" And he says, "I didn't think it was possible." And then he said, "Yes, okay, and then we explained certain rights, and for cause you asked for a lawyer, and we ended the process, correct?" And then shortly thereafter, Detective Calveo again clarifies, "And at this moment, you said that you wanted to talk to us, that you wouldn't need a lawyer here, and that you would like to talk to us about this case, correct?" And the defendant says, "Yes." So the record here indicates that the defendant understood both, that he could have an attorney there at the time, and could have him despite the inability to pay. This case is a far cry from what happened in the recent SJC decision of Santos. In that case, we have very different defendants. First of all, the defendant in Santos fled from the police upon their arrest and was very evasive with the police throughout the whole interrogation. In this case, we have a defendant who turned himself into the police, who wanted to tell his story to the police. In fact, on the first day, he says, "Yes, I'll talk to you, just not today," indicating that he wanted to go sleep. The next day, the police do talk to him. He is very cooperative. The flavor of the interrogations were very different. The police, this isn't a case where the police talked the defendant out of the invocation of his right. This is
Could I pause there for a minute?
Sure.
I do see that there's a summary by the police about what it is that the defendant might have said during the time when there wasn't a tape.
Yes.
But that statement, that summary of what the defendant said, isn't actually what the police officer testified to at the motion to suppress hearing, is it? Doesn't actually find its way into that hearing.
It is in the hearing at the motion to suppress. There was testimony taken. It's
Yes.
not on the recording, and that's why it's not translated in the transcript. So what happened,
You mean there's a piece of the motion to suppress that's also missing?
let me back up and explain how it played out at the hearing. There was a recording. Everything that was on the recording was translated into English, taking into account the way that the defendant would understand it with the Brazilian dialect.
And there was a period,
That was off the tape.
correct,
And that,
that was summarized by the police officer
right.
as saying, at this moment, you said you wanted to talk to us, but that we shouldn't, that you wouldn't need a lawyer here, and you'd like to talk to us about this. So that's pretty important. But that's a summary, correct?
That's the summary. And there was testimony, however, that supplemented exactly what was discussed during the time when the tape was off. And that's Detective Calveo's testimony, and I believe another, I think Trooper Donahue also testified at the motion to suppress hearing and stated that when the defendant invoked his right to have a lawyer present, they turned off the tape and they got up to leave. And at that point, that's when the defendant reinitiated the conversation and asked the investigating officers whether or not they were Mormon. And he also wanted to which they all said no. And the defendant also wanted to clarify or certify that he had a right to stop questioning anytime he wanted and only answer the questions that he wanted. And the police officers did tell him that was correct. And he said, well, in that event, I will talk to you. And that's when the police officers left the room for 40 minutes to discuss this before going back in and re-Mirandizing the defendant for the fourth and final time, where he did voluntarily waive his Miranda rights. And then the tenor of the interrogation from that point forward is the defendant leading the entire questioning from the point where he met the victim up until the point where he killed the victim and her stepson. At 2 points during the questioning, Trooper Donahue tries to focus the defendant to the night before, the previous night when he killed them. And the defendant says, hold off, wait a minute, I'll get there. So it shows that the defendant led this, and he wasn't talked out of or cajoled out of his desire to speak with police. This is a defendant who wanted to speak with police, and that's what we have here in this case.
Testimony at trial about this also in connection with humane practice?
Yes, there was. Everything was, again, relitigated, very similar to the testimony that was elicited at the motion to suppress hearing. It was the defendant's theory that it wasn't voluntary, that either based on language or based on the fact that he was told that the Miranda rights weren't sufficient for him to waive.
What do we do if there's anything that we can do about what seems to be a lot of imperfect translations of these rights? Is this fixable in any way, or do we just have to live with the fact that we're going to have imperfect translations?
Well, the case law seems to say that there's no magic words, and they don't require police officers to give the exact Miranda warnings every time. All that's required is that it's all the rights are fully conveyed to the defendant. Mm-hmm. And the case law doesn't require that a certified translator be brought to the station or on scene every time Miranda is given. So unfortunately, I think we are dealt with the hand that we deal with this on a case-by-case basis to make sure that the rights were fully conveyed to the defendant and that he understood them before waiving it.
What do we make of the fact that there were rights posted in writing in Portuguese? I mean, and is there any indication that this defendant was or was not literate or able to read?
There was nothing to say that he was or was not literate. The testimony was that the defendant seemed to read along with the officer.
Now, the waiver that he signed having received Miranda rights, was that in Portuguese or was that in English?
I believe there was one form in Portuguese and one form in English.
Is that in the record?
Yes.
But about that, which Portuguese?
Because
Because when there's a translation, of it, it sounds as though even the Portuguese-speaking officer didn't do a really great job. So I'm surmising from that it wasn't the kind of Portuguese he was familiar with, or I don't even know.
In all the translations that you have in the record from the motion to suppress, they're all translated so that in the dialect that the defendant spoke. So you're reading the English as the defendant would understand it. So you're assured not to see.
So the officer didn't read the officially translated version of Portuguese, is what I think you're saying.
From the
He translated in his own understanding of what it was in English. He didn't read the Portuguese translation, and whatever it was, whether it was Brazilian or continental.
He read the Miranda rights twice in Portuguese as they were stated on the board in the booking room. They're listed on boards in different languages.
What I'm reading in here is actually what it says.
Yes, it's actually what it's posted on the board the first time.
That's
the
also
first set of
a little-
Miranda. The first set of Miranda warnings.
Is there any indication that written Portuguese is different? I mean, I understand they can be, a written form of a language can be the same, even though a spoken form can be different depending upon dialects. Is there any reason to think that Brazilian Portuguese, when written, is different than continental Portuguese when written?
There was no testimony on that, written versus spoken language. But the first set of Miranda rights read from the board were
In Portuguese.
in Portuguese were sufficient. It's just later when the
Were they?
I believe.
Because I'm going to read it. I'm going to read it. If you cannot obtain a lawyer, the court will point one out to represent you. Understand? Do you understand this right? When you go to the court, if you do not have assets, the court can point one out. Is that if that's the translation? Maybe that's just a suggestion that maybe people ought to be looking at what you've got there.
Absolutely, and we've seen this before in other cases in Khmer where it wasn't the translation wasn't exactly right. But I agree that police departments should be looking into the translations. I think that's a fair thing to bring back to the DA's office.
Do we know whether the words "point one out" in the translation have a different meaning in Portuguese among Portuguese speakers than they do among English speakers?
There was no testimony on that point. However, it does seem to say throughout the different iterations of that right that if you don't have the possession of hiring attorney, you will be supplied or recognized before being questioned, and if you decide to answer questions, you have the right to stop. So it doesn't just say point out or appointed. There's also supplied. One will be named to you. So there's different ways that it's said.
Could I ask you to talk for a moment about the voluntary manslaughter instruction?
Yes.
The judge declined to give one. The defense theory of the case was that it wasn't first-degree murder, it was something less culpable because he snapped.
That's correct. However, there was no, even viewed in the light most favorable to the defendant, there was no evidence to support reasonable provocation to warrant a voluntary manslaughter instruction. First of all, there's the general rule that mere words are insufficient to produce the requisite state of passion in a reasonable person.
Didn't she try to grab the baby away from him? So wasn't there some physical?
There was that physical and maybe even a pointing in the chest.
Yeah.
That was the extent of the physical confrontation, if at all. And I would suggest that's certainly not enough to warrant a reasonable passion in somebody to not hand over the baby or to point in someone's face in order to justify a lesser degree of culpability. Even and then turning to the words, it seems from the defendant's brief that he's trying to say that the imminence of deportation is enough to warrant the angst in someone to be given this, to warrant a voluntary manslaughter instruction. But I would submit that, especially in this case where the defendant's own statement, he states that his stepson Kayaki, he did threaten it prior. So this isn't the first time he's being threatened with this. And even if that's what we have, it was the first time, the imminence of being reported to INS or ICE is not enough to warrant someone to kill another person, or to give a lesser degree of culpability. The passions, it's not equatable to finding your lover in bed with another person, which is where the case law seems to be going with this. And that's has to be your first time that you're seeing this. It can't be something you know, and then you come upon it. This is something much more than what happened in this case. There was nothing so personally offensive that it would cause a person to snap. There was nothing new that happened that night on the night of the murders where that the defendant didn't already know about. And there was no evidence of an immediate so-called snap. The defendant didn't pick up a weapon right there in that same room and inflict injury. He left the room.
He was calling 911.
She was calling 911 in the bedroom, and what happened was, rather than upon picking up the phone and calling 911 or recognizing that the Carla was on the phone with 911, the defendant didn't pick up whatever was at hand and hit her. What he did was he left the room and came back with a weapon. That is not sufficient to show that he snapped under the heat of passion. He had time, and this also ties me back to the deliberate premeditation, which is the closing argument issue. He had, what the prosecutor pointed out in closing, volume 18, page 102, the trial prosecutor stated, he goes outside of the room, and at that point, he starts to reflect on his life. I'd suggest to you that he has time to deliberate. He doesn't walk out the front door. He grabs the hammer and decides, I'm going to strike her dead, and that's what he did. This is a defendant who could have, the closet where he retrieved the hammer was right next to the front door. He could have kept walking and left the apartment. Instead, he goes to that closet, retrieves his hammer, and goes back into the bedroom, where he then hits the victim 6 times in the head using this hammer, and then turns the hammer on his 11-year-old stepson. This is a much different, this is a case where reasonable provocation was not shown by the defendant, even the light most favorable to the evidence.
Do you want to say something a little bit about the hearsay statements of the victim and whether they were properly admitted, and if not?
Yes, Your Honor, thank you. There are 4 portions of the testimony where the victim's hearsay statements are elicited. The victim's state of mind that was found within that hearsay testimony is the victim's unwavering devotion to the Mormon Church and hosting the Mormon missionaries in her home, despite the defendant's wishes that she cut ties with the church based on his complaints that she spent too much time with the church and his unfounded infidelity suspicions. This was the major source of the escalating sense of the defendant's frustration with his inability to control this victim, and therefore was relevant to his motive to kill her. The Lowe decision makes a distinction between statements of intent and plan versus statements of memory of past facts. Even though the testimony that was given were conversations that happened in the past that conveyed events, what was important to the case was to show the victim's unwavering devotion and her intent, to her future intent to stay devoted to the Mormon Church. This case is a little bit different because the incidents recounted do involve some of past incidents. It's not just her statement that she planned to stay with the church, but to the extent that this case is also very unique because the primary concern with hearsay, its reliability, doesn't exist here. We know, we can be assured that this did happen because of the defendant's statement. The trial judge in this case limited the hearsay statements to that which could be found in the defendant's confession. So there was no real problem as far as hearsay is concerned. And the judge, with regard to any of the defendant's bad acts that were tied up, that were part and parcel with the victim's testimony, the victim's hearsay statements, the judge was also very careful to make sure that the jury did not consider that evidence for the defendant's propensity to commit the murders, because he gave a limiting instruction during both the Commonwealth's opening statement when the prosecutor pointed out that defendant's motive was this disagreement about the church, and also he gave the limiting instruction during both witnesses' testimony. And I would also point out that this evidence was not used by the Commonwealth to prove deliberate premeditation, as can be seen by the Commonwealth's closing argument. The Commonwealth, which I already recited, the Commonwealth was focusing on the time it took to go from the bedroom to the closet and back, and that was when the deliberate premeditation was made.
On the statements that the decedent Carla made, what about the ones that refer to the defendant's verbal abuse of her? Was all of that in his statement?
In his statement, he goes through and talks about the good times and then the deterioration, and he doesn't say that I called her a prostitute.
Or that she was unfaithful, having a taste for younger men and so forth? Right.
He does.
Doesn't say that he said those things.
He doesn't say that he said those things. The judge said that second layer of hearsay was cured because of it was a party opponent statement. But in any event, it was cumulative of the same tenor of the defendant's statement, and with the limiting instruction, there was no prejudice to the defendant because the jury was instructed to use it in the correct manner.
Thank you.
Thank you, Your Honors.